Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson. What we're going to talk about today is what's called a Dram Shop Act, or an act that relates to liquor liability. Florida has adopted, as a matter of its public policy, a highly protective statutory scheme or design that protects people who sell liquor. Now, they justified in Florida by saying that we are a tourist industry and therefore we should protect our tourist industry that sells liquor and beer and wine and whatever. But here's how it works in Florida. You would think, let me give you an example, you would think that if a person came into a bar with their friends, started drinking, and their friends all leave, and they keep drinking, and they become just slobberingly drunk. But that's the first time that that person has ever been in that bar. They're tourists. They come from Wisconsin or Minnesota or, Dakota, someplace that's a little colder than Florida. And so they're here, and so they're drinking, and the liquor people keep serving them. Bartender keeps serving them. This person becomes slobberingly drunk. Just can't talk. They're slurring their speech. They can't hardly hold their car keys. Their keys keep falling out of their hand. But they pick the keys up. Everybody's watching them. The bouncer, the bartender, the manager, everybody's seeing him. Everybody knows this person's dead drunk. And they leave the establishment. No obligation in Florida for the bar owner, the bartender, the bouncer, or any employee to protect that person from killing someone else by getting drunk and getting in their car. No requirement of law for them to do anything. All they're allowed to do is to sell him all the liquor he'll drink. So then he leaves, causes a terrible accident, causes a death, and a lawsuit follows against the bar owner. And the lawsuit says you knowingly served this person. You knew he was drunk. You saw he was drunk. You kept serving him. You kept making money because he was drunk. In Florida, no claim. No claim, because the Florida legislature is dead set solid on protecting people who sell liquor. That's their goal. It's every year is the same way. The liquor establishment in Florida is the most powerful, probably the most powerful lobby in Florida. And the statutes that have been passed are very, very protective of the liquor industry and very unprotective of society and innocent people that are killed by drunks. But here's what the statute says that you can recover for, and it's very, very limited. A person who sells or furnishes alcoholic beverages to a person of lawful drinking age shall not thereby become liable for injury or damage caused by or resulting from intoxication of such person, period. But they have a comma. And now is where you get some possibility of a claim, except that a person who willfully and unlawfully sells or furnishes alcoholic beverage to a person who is not of lawful drinking age. So let me stop right here. What does that mean, willfully and knowingly? It means that the bartender has to know they're underage. He has to know it. They have a false ID. He doesn't ask. The bartender's negligent in seeing whether they're underage. No liability. You must prove that the bartender willfully and knowingly served a minor in order for the bar to be responsible. That's for serving minors. Or who knowingly serves a person habitually addicted to the use of any or all alcoholic beverages may become liable for injury or damage caused by the intoxication of such person. So what does that mean? If you have a known alcoholic that stays drunk in the bar every night, then yes, in Florida, you may bring a claim and you may be able to recover if the bartender and the bar knowingly serves an habitual alcoholic to the point of intoxication. But you can see the problem. The problem is we're a tourist state, and the tourists come here and they may not know anybody in the bar. and they are celebrating, they're happy, they're kids, they get dead drunk and go out on our highways, and when they cause accidents involving the death or serious injury of one of our citizens, there's no recovery against the dispenser of the alcohol. It's a terrible law in Florida. It's very, very difficult to recover against these bars. And even when you have a minor in there, now, one thing you can prove and you can show is if a person is obviously looks like they're 12 years old, yes, you can prove it circumstantially. But normally, you have to prove that the bartender, the person serving the alcohol, the manager, somebody absolutely knew this person was underage. These are extremely difficult cases. We've had success with these cases because we understand the twists and turns that are involved here. But this is a very unfair law, highly protective of the liquor industry, but that's just the way it is with this Florida legislature and the state of Florida now. For information or for a discussion of a possible claim resulting from the sale of alcoholic beverages to either a minor or to a person who was intoxicated and caused an accident, we'd be happy to discuss your case or look at it, and there's no charge or obligation. Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson, Kerrigan.com.